A Minnesota man is accused of killing the mother of his child and leaving their 2-year-old daughter alone in the home with her body. According to police, the 34-year-old suspect allegedly confessed to the crime to a family member who then called authorities. When officers arrived at the home, they found the woman's body wrapped in a blanket and say she had multiple stab wounds. I'm your host, Kennedi Walker, and I'll walk you through the details. According to St. Paul police, back in September, Christine Morris shared a warning with a friend. If anything happened to her or her daughter, she said Joseph Davis would be the one to blame. Now, 8 months later, Morris is dead and Davis is charged with her murder. According to court documents obtained by Law&Crime, investigators say Davis called a family member and admitted to killing the mother of his child. He apologized and told them he had left their 2-year-old daughter alone inside the home. Police say when an officer called Davis to confirm what happened, Davis hung up as soon as the officer identified himself. When officers arrived at the home, they found the toddler sitting on a couch in the living room. Upstairs, they discovered Christine Morris's body, wrapped in a blanket. Investigators say she had multiple stab wounds and was cold to touch. The Ramsey County medical examiner later determined that Morris had been stabbed in the head, neck, chest, back, arm, and torso. Her right lung, kidney, spleen, diaphragm, and colon were all pierced. Detectives began piecing together what led up to the killing. According to police reports, one of Morris's friends told officers she had been with Christine the day before her death and that Davis accused her of cheating. Another friend shared text messages from Morris sent back in September, where she warned that if anything happened to her or her daughter, Davis would be responsible. Court records show Davis has a history of domestic violence. According to those documents, he was convicted 3 times, once in 2023 and again in 2024 for domestic assault. He was also found guilty of violating a no-contact order in June of last year. In all 3 cases, police say Morris was the victim. Another woman, who shares 2 children with Joseph Davis, told police he called her the morning of the murder. According to court documents, Davis allegedly left a voicemail saying he had killed Christine Morris and wanted to see his children before turning himself in. The woman told investigators Davis had a history of violence and that she had a protective order against him. She had previously expressed concerns to her lawyer that she had concerns that he would kill someone at some point. Officers eventually tracked Davis to an apartment in Minneapolis that belonged to a woman he had recently met on a dating app. In an interview with investigators, Davis allegedly admitted to killing Morris after she returned home from a night out on Thursday. Davis accused her of cheating and manipulating him for 5 years. He reportedly told detectives he had set up a recording device inside the home, which he claimed captured Morris with another man, but later admitted the footage was grainy and hard to hear. As he recounted the stabbing, police say Davis told investigators the attack was not planned, reportedly saying, quote, "I should have never did that to her. That was brutal. I definitely feel bad." He also allegedly told investigators, quote, "She suffered, bro. She definitely suffered." Davis is now charged with second-degree murder. In the days after her death, Morris's friends and family took to social media, sharing memories and tributes to the 32-year-old. Just weeks before her death, Morris posted this on Facebook, writing, quote, "Women, stop putting your hands on these men. Men, start getting restraining orders on these unhinged women, because if you put your hands on her, you're going to jail." She went on to say, quote, "If you gotta fight your person, they're not your person." Now, the father of her child is behind bars, accused of killing her. Her family has launched a GoFundMe to help cover funeral expenses and support her young daughter. In the fundraiser, they described Morris as a beautiful soul who touched many lives with her love, strength, and smile. And joining me to talk more about this is criminal defense attorney Joe Tamburino. Joe, thank you so much for coming on today. Let's just jump right in. Based on the evidence outlined in the complaint, how strong is the prosecution's case against Joseph Davis?
Thank you for having me on, Kennedy. It's extremely strong. I mean, think of it this way. They have background, meaning he's got prior domestic violence offenses. They have all of the physical evidence, and they also have his admission or confession. He clearly stated to, it looks like, several people, including the police, that he did it, that he shouldn't have done it, that it was a very grisly or gruesome thing that he did. So if everything in the complaint is true or accurate, yeah, it's a very strong case against him.
How many years is he facing?
Well, here's the odd thing. They've only charged him with second-degree intentional murder. Under Minnesota law, under the sentencing guidelines, he would be sentenced to what's called 25 years, but with good time. So if he was convicted of just this, intentional murder, he'd be out in 16 years, which isn't that much time. However, if he were to be charged with first-degree murder, he would have to spend at least 30 years in prison before eligible for any type of release.
In your professional opinion, why do you think that they haven't charged him with first-degree murder? Is it that they are concerned about intent?
Well, I hope that's not the case because it looks like they have intent. And for first-degree murder with prior domestic abuse incidents, you don't need to have premeditation. You just need to have intent and the prior bad acts in the past, meaning that he had prior violent offenses, domestic abuse offenses against significant others, including the victim in this case. So they've got the information to go to a first degree. I'm a little perplexed why they haven't, because in Minnesota, you can charge out by complaint first-degree murder. And after you do that, you have 14 days to go to the grand jury. So it could be a situation where they don't want to be rushed to the grand jury, but I would imagine if this doesn't rise to first-degree murder, what else does?
And if his attorney, realizes the same thing you're realizing and says, hey, we need to take this immediately, and they, plead guilty to that, are prosecutors allowed to say, oh, wait, never mind, I want to charge him with this? Or do they just kind of have to take what they have?
That's an excellent point, Kennedi, because right now, if he and his defense attorney run into court and say, we want to plead guilty, yeah, that's going to be a problem. You see, what the prosecutor has to do would be amend this complaint to do first-degree murder with a notice that they're going to go to the grand jury, and that would stop the presses. He would not be able to enter any type of guilty plea. So you're quite right. I mean, if he and his defense attorney, public defender, what have you, run into court and try to enter a plea of guilty on this, which would be beneficial to them if everything's accurate in the complaint, that's a problem.
Does the existence of past protective orders strengthen the case against Davis?
Absolutely. Whenever you have a domestic violence murder, which obviously, if everything is accurate in the complaint, this is, having the priors of domestic violence only adds to the evidence that the prosecution has, because they're able then to get a greater charge, like we just discussed, first degree, if they wish to go there. But they also can do something like prove motive. Now, motive is not an element to any crime. They don't have to prove motive in any case. However, when you're in front of a jury, many people, many times think, well, why did this defendant do that? Well, these priors show a prior behavior of domestic violence, as well as control type of behavior, because in the complaint, we see that he was very controlling, according to the complaint, that he was worried about her being unfaithful to him, that he basically wanted to control the situation.
And that he was convicted 3 times of domestic violence in 2023 and 2024, and then again in 2024 just for breaking that protective order. So it looks like that the prosecution would have a pretty open and shut case, correct?
Absolutely. If everything's accurate in this complaint, they've got a solid case.
How does an alleged confession like Davis's voicemail and police interview impact the prosecution's case as well?
It's solid, because when you have a defendant who confessed to a friend, to somebody that they know, it has a high degree of trustworthiness. Why? Because they're telling a friend, they're telling a confidant, they're telling someone that they trust that they did the crime. So it has a high degree of credibility. Additionally, as you can see in the complaint, when the police arrested him, the police made it clear in this complaint that they read him Miranda. And then after being read Miranda, he waived his rights and gave a statement confessing to the murder. So these two types of confession buttress the state's case greatly.
Now, according to the complaint, the victim had allegedly sent a text message last year in September saying that, hey, if anything happened to me or my daughter, it's most likely because of Davis. Could Morris's text warning Davis could hurt her, could that be used in court?
It would be very difficult to get that in because of our hearsay rules. There would have to be a specific exception. You might be able to get it in under effect on the listener, but just straight up that, unless it was some type of excited utterance, it would be hard to get that into court. But even if it did get into court, I don't think it would hurt the victim side of the case. I think it would greatly hurt the defense side of the case.
Yeah, well, you're just wondering if that would be possible, if they were able to prove that it came from her phone. And again, yeah, not hurting the victim's side, but if it could hurt, Davis's side, if it could help the prosecution out, if they were able to show this text that, hey, the victim, she was, allegedly scared, according to this complaint, according to text messages that she sent her friend last year.
Correct. It would help the prosecution's case, no doubt. But those types of words by a victim who obviously is not present and can't testify in court, unless there is a specific exception to the hearsay rule, which, just based on this complaint, I don't see any. We'll have to see what the evidence is when it goes to trial. If it goes to trial, it would be quite difficult to get that statement in.
Could Joseph Davis face additional charges for leaving his 2-year-old alone with Morris's body?
Yes, but at this point, if they ever charged him with first-degree murder, it really wouldn't have any consequence because if he's convicted of first-degree murder, he would have to be in prison at least 30 years. So sure, they could charge him, but to what end? It's really not going to matter in the end.
If they don't charge him with first degree and it stays the way that it is, would they be able to add on? What would that be considered, a child abuse charge or something along those lines?
Yes, they could. The problem is if they don't change it to first degree murder, he might just run in and plead guilty, or he could try to form some defense that it was really a heat of passion. And that's going to be difficult defense. I mean, heat of passion is always a difficult defense. But if he prevails on that, then, potentially he could get a manslaughter, which is a lot less of a sentence.
Speaking of just leaving the 2-year-old, what does Minnesota law say about exposing children to violent crime scenes?
Well, you could be charged with basically child abuse. There are different statutes about if you are a negligent parent or if you put your child in a dangerous situation where they could receive bodily harm or great bodily harm. And clearly, just leaving a young child alone, especially in this type of a situation, would fit that. But, it's not going to carry years of prison. In most of those situations, it would be what's called a stayed sentence.
Would prosecutors likely consider a plea deal in a case like this? I know we already talked about it. It looks like it's open and shut, but could it happen?
Oh, yes. I mean, plea deals always happen, even on open and shut cases, because, we in the public don't know what the full extent of the evidence is. The prosecutors do, the police do, the investigators, and eventually the defense attorney will have that evidence as well. But, it's hard to second guess a prosecution if they do offer some type of plea deal.
If you were the suspect's defense attorney, how might you build a case around, maybe mental health or emotional distress? How would you go about arguing this?
Well, the only mental health defense per se that we would have in Minnesota would be mental illness. You would have to have evidence, and the burden's on you, that your client was under such a mental defect, whether it's organic or something that happened to him later on, that he didn't know the nature of his acts and the consequences of the acts. That's going to be awfully hard to prove in this case because if this complaint is accurate, we have a defendant who supposedly confessed to the crime at least twice, talked about how it was, basically a gruesome crime and that the victim suffered, which shows that he has a presence of mind. It shows that he's able to relate and remember the facts. It doesn't appear that there was any type of mental defect or any type of problem with his sanity.
Now, we kind of touched on this a couple of minutes ago, but could Davis argue self-defense or provocation based on the cheating accusation?
Self-defense, according to this complaint, would be very difficult because in self-defense, the person using the violence, Davis in this case, would have to show that he was under such fear that he had to use deadly force against the other person. And based on what's in this complaint, I just simply don't see that. In terms of trying to do heat of passion, yes, that's a defense that is available. Quite difficult to win on it. And based on these facts, it would be difficult because with heat of passion, it has to be something that so stirs the emotion in the immediate time that the person just lashes out. Doesn't make them not guilty. It just makes the crime less. So, we could use the very common example of a person who walks into their bedroom and their wife, their spouse, is literally engaging in sexual activity with someone else, and the person either kills or hurts that someone else. That's the best example of like a heat of passion. It doesn't exonerate the person, it just lessens the time. But under the allegations in this complaint, even that would be quite a stretch.
And we saw, according to the complaint, that police are claiming that Joseph Davis, he admitted to the crime to police. Could the defense try to suppress any of those statements to police?
Yes, I mean, you could always do a suppression hearing. The issue there is, was the person in custody? It seems like Mr. Davis was. And the next issue is, what was he read his Miranda rights? And it seems like he was. And then did he do an intelligent waiver of those rights? And according to this complaint, it seems like that was the case. Now, again, a complaint is not evidence. This complaint never goes to a jury. A complaint is simply there to give the defendant and the public a synopsis of what the case is about. So, if there's evidence that comes through in this case months from now, that something prevented Mr. Davis from understanding what he was doing when he waived his rights, sure, you could have a suppression hearing.
And we've touched on the fact that Mr. Davis has previous convictions related to domestic violence against the victim. How common are cases where prior domestic abuse escalates to homicide?
Well, fortunately, they're not common. There are cycles of domestic abuse. There is no doubt about that. And you see many times in court that the person who is accused or charged with domestic abuse has a history of domestic abuse. But thankfully, only a small percentage result in a death. Now, of course, you don't want to have any deaths in this area. Even one death in this area is too much. But statistically, it's not a great number that we see deaths.
Are protective orders effective in preventing tragedies like this?
For the most part, they are effective. Unfortunately, what we see many times in the system is that even though there's a protective order, sometimes the defendant breaks it, simply doesn't care about the order and goes ahead and contacts the other person, or the other person, the person who is trying to be protected, also goes against the order, starts contacting the defendant. So for the most part, I think orders for protection and restraining orders do work. But of course, there's a certain percentage where, regardless of any order in place, there are still violations.
What legal resources do victims of domestic violence typically have at their disposal?
Well, here in Minnesota, there are great resources. Minnesota, I think, is definitely head and shoulders above most states in providing resources to victims of domestic abuse. Every county, there are 87 counties in Minnesota, many of them, or most of them, quite rural, and there are domestic abuse help centers. They might not be exactly in that county, but there are ways to get, phone calls into domestic crisis centers, emails, get people to come visit you, go visit them. So thankfully, there are great resources throughout the state.
So can you just explain what happens now? What happens next now that Mr. Davis has been formally charged?
He'll make a first appearance in court. His bail will be set quite high. On the complaint, it's listing a $2.5 million bail. I would imagine that's going to stick. He won't be able to bail out, or highly unlikely he would. And then there'll be a number of court appearances after that. Things like, evidentiary hearings, pretrial settlement conferences, discovery conferences. But the big thing to look out for is, will the prosecutor put the court and the defendant on notice that they're going for first-degree murder? And they can do that at any time. I would suspect they would do it pretty quickly, but obviously it's up to them.
How long could it take for this to even make it to trial, though? Are we talking about months, years?
Likely a year. For example, if they, meeting the prosecutor, went to go for first degree, you'd have to impanel a grand jury, you'd have to present evidence to the grand jury, and you'd have to let them decide. So say they decided to indict for first degree murder. After that, likely a year before this would ever hit trial, because the defense would challenge the grand jury indictment, or they have the right to, and there would be a number of court appearances. There could be motions, things that a judge would have to take under advisement and issue decisions. So it could easily be a year. And even if they don't do a first degree, and I would be surprised if they didn't, still you're looking at a lot of time for litigation. Now, people hear a year and they think that is really too much time. But in the scheme of things, on any murder case, having it resolved by jury trial within a year is quite expeditious.
Any idea on what happens to the little girl now that her mom is deceased and her dad is in jail for her mom's murder?
That will all depend on her family or social connections. Obviously, if there are other family members, aunts, uncles, people who are close to the girl, sure, the social service system can easily try to effectuate that the child will be with family members. So it would depend on what kind of family structure she has. If it's an even further unfortunate situation where she doesn't have any family resources, well, then it would clearly go through the social service system. There could be foster care and such.
Well, this is a case that we will be following closely. Joe, thank you so much for joining me today.
Thank you for having me on.
According to KSTP News, Davis's next court appearance is scheduled for June 17th. Reporting for Law and Crime, I'm Kennedi Walker.